You're watching TVC Breakfast. Now, there are indications that Nigeria's plan to have the $9.6 billion awarded in favor of process and industrial development nullified on the grounds of allegation of fraud may fail.
This comes following the September the 26th ruling of the London Commercial Court. The court is, in its ruling, granted Nigeria leave to appeal against the enforcement of the $9.6 billion arbitration award.
Now, but the court said it did not consider Nigeria's allegations of fraud and tax evasion in granting the stay and leave to appeal. Now, the Attorney General of the Federation, Abubakar Malami, had said that Nigeria would rely on the established case of fraud in the GSPA in setting aside the $9.6 billion award.
The federal government, however, is insisting that the P&ID deal is one which was designed to fail and a big scam. Well, joining me now is a lawyer, an international lawyer, Olufemi Aina. Thank you for joining us on TVC Breakfast. Well, it seems that Nigeria may be insisting that this is a scam, but the UK courts are saying that the allegations laid before it that got us that appeal, it's not what it relied on. Yes. And so it seems that it might be a little challenging for us to prove that this was fraudulent and all of that in the first place.
No, that opportunity is not totally lost, because we need to get this right. It's just unfortunate that some of the information that has been coming into the public domain, they are not totally accurate. Okay. The hearing on the 26th of September was about the enforcement. You know, initially in August, that arbitral award was converted into a judgment. Mm-hmm. And then there was a plan to seize Nigeria assets. So the judge now said, look, I'm not going to give you an order to go and seize their assets without hearing from them. Yeah. So the matter was listed for September 26th. In between that August and September, Nigeria has managed to come up with all these allegations of fraud here and there. And the judge on that occasion will probably say that, look, this is not why we are here. Why we are here is whether these people should be, I should give them permission to what is called an attachment to seize your asset. That's why the judge said, look, the issue of whether there has been fraud or not is a different matter entirely. So it is not that that opportunity is totally lost. What Nigeria needs to do, since they have this allegation of fraud and what have you, they will need to make a separate application in that respect to set the arbitral award aside in the light of new evidence which has come to light, which is the fraud. Now, the judge now said, look, as regard the enforcement, I'm going to give you leave to appeal. However, I'm giving you what is called a conditional leave, that you have to pay XY amount of money.
$200 million?
Yes, otherwise, the stay, which I'm granting that they must not attach your asset, is going to be lifted, in which case they can seize your assets, which P&ID has managed to identify here and there. So that's what the judge did. And now, they have a leave to appeal. Nigeria can appeal that, okay? And they said you must do that within 60 days, pay the money, put in your appeal. And then what Nigeria is now saying is that even though you said we should pay $200 million.
We want to appeal that.
We will appeal that. But there is a clause there. There is no problem. They can appeal it. But that has to be done in a very punctilious way. Otherwise, if they are late, there is going to be a problem. The alternative is that that money is not going to P&ID. We need to get that clear. That money is going to what we call court fund office. And it's going to be there till the end of the appeal. If Nigeria succeeds with the appeal, the money will be returned to Nigeria. But if they fail, the money will go to P&ID. But the other aspect is the $250,000. That is regarding the legal cost, which has been incurred.
£250,000?
Yeah, the $250,000. I think pounds. Yeah, thank you. That is the legal cost, because at that hearing, there's going to be what we call a schedule of cost from P&ID, maybe Nigeria, because don't forget, Nigeria is the loser here because they lost the case during the arbitration. Now, the judge will have looked at that and said, oh, I've seen the schedule, But for now, I'm not going to deal with the issue of cost, but I'm going to make what is called a summary assessment, whereby the cost is assessed right there and then. The opposite of that is what we call detailed assessment, whereby you can challenge the cost. And the judge now said, go and pay this for now. And there's one point which we need to make clear here. Come what may, it may well be Nigeria will succeed in the long run with the appeal, with this allegation, if they manage to get it in. But the issue is this: Nigeria will still be able to, will still be made to pay some cost, because number one, you are the one who didn't do things in time. Number two, you are the one coming with this new evidence at the, later in the day. So because of that, the other side, even if they succeed at the appeal, I know those judges are going to say, can you pay the other side cost up to this stage? And then from this stage, you don't pay cost. So that's what the judge did. The judge must have taken a view that, look, come what may, you will still be liable to pay some cost, but pay part of it now. The other underside to that is that Nigeria is giving P&ID money to fight them, because at least they still have 250,000 in the kitty.
Now, officials of the federal government have said at one time that the stay of execution is the proof of allegation of all the allegation of fraud, tax evasion, and all of that against P&ID. But the court, through Justice Christopher Butcher, saying, no, we didn't consider the issue of stay of granting of the stay of and leave of appeal is not on the ground of the allegation of fraud. Yes. Now, what are the implications of this?
The implication is very simple. Number one, in granting leave to appeal, there are two tests. Is there a compelling reason, one, and then is there a prospect of success? And it's not impossible. The judge must have taken all those two factors into consideration before granting leave to appeal. As to the issue Nigeria is raising about these fraud allegations here and there, somebody must have mentioned that to the judge at a point anyway. But what the judge is saying is that, look, that's not the primary consideration now. I'm giving you leave to appeal because I believe that, look, there's a prospect of success. But having said that, I'm going to grant you leave on conditional basis that you must do this, you must do that within 60 days. And Nigeria is now saying, look, you asked us to pay $200 million within 60 days. We are going to seek a stay of execution on that part of the order. And everybody is going to the media, P&ID, the Nigerian government, but nobody has even shown us a copy of the order. And because in this sort of matter, the order can easily be drawn up right there and then at the end of the hearing. And the judges just say, wait outside. The clerk will bring the order to you because there's a legal clerk there typing everything. But my major concern is this: rather than engaging in all this bric-a-brac here and there, what Nigeria needs to do now is to keep their eye on the board. They have 60 days deadline to make that payment. If they want to apply for a stay of execution, it's not a rocket of science. One, make your application, put your witness statement in, lodge it at the Court of Appeal, and it's a single judge that will consider that in chamber. If you don't get the order, go and make the payment. But the way we do things, if they leave it to the last minute, well, they may have to pay the 9.6 billion.
All right. Let me put you on hold here, and then we go on a break and we'll come back. We've been talking with Olufemi Aina, a UK solicitor and a lawyer, and we'll come back to this shortly. Stay with us. You're watching TVC Breakfast. We have been dwelling on the case between the federal government and P&ID, where the federal government is insisting that there has been a scam, and therefore the order to pay $9.6 billion against them, it should be a nullity. But we have a UK solicitor here giving us insight into implications from all sides as to how the development on the case is going right now. Olufemi Aina has been with us. Well, thanks for staying with us. Yes, now, the Nigeria is trying to institute a fresh case, you know, bringing something fresh to the ground. As in, there are evidence, there are proof that this case or this the contract was designed to fail from the start. And so the claim of them breaching the agreement does not stand.
Yes.
Now, how does this impact on the ongoing case?
Yes, it's going to have a significant impact because don't forget the enforcement order stand and fall on this contract.
Okay.
And what Nigeria needs to do now that they have this fresh evidence that, look, there are a lot of underhand dealings here. What they need to do, that is a good grant in which to move to try and set aside the arbitral award. But they still have a difficulty because, number one, there's something in the UK called the Ladder-Marshall principle that, one, this is an evidence you couldn't get in time, and now that you have the evidence, it will make a difference to the original decision.
Okay.
So that is one hurdle they need to cross. But there are two appeals here. Even what is an appeal? An appeal is a review of the original decision. And what Nigeria needs to do, there's the arbitral award, this happened, that was in 2013 or so. That was when that award was made by the panel, the tribunal. Now, 2019, you now have the evidence of fraud. Now, you need to approach the court to try as much as possible on the basis of procedural irregularity and what have you, to have it set aside. And that is what they need to concentrate on. At the same time, you have an enforcement proceeding, which is ongoing. It may well be in the long run, all the two matters will be consolidated. But my major concern is enforcement proceeding, which is ongoing. It may well be in the long run, all the two matters will be consolidated. But my major concern is this. If we need to try as much as possible, and either we set up a small committee or panel who will be liaising with the lawyers in London to make sure that we don't miss the deadline. That is the major concern because, Nigerian conduct regarding this matter hasn't been satisfactory. Rather than engaging in a unnecessary PR exercise, because you are talking about 9.6 billion. You're not even talking about the legal cost. The legal cost in this matter might be running to about 3 million. And care needs to be taken because don't forget P&ID, they've hired a PR company. They pay $50,000 to an expert. Who is going to pay? Somebody is going to pay
Foot
that
all the
back.
bills.
Yes.
How long do you think this case is going to last from your perspective?
From the look of it now, it's becoming a merry-go-round exercise because, you have a stay of execution regarding enforcement. You're going to have another appeal regarding the setting aside and what have you. As things stand, if care is not taken, I don't think it's going to happen this year anyway. It'll probably be sometimes next year when the appeal court will see it and they will try as much as possible to consolidate all the proceedings. But on the other hand, my major concern is that if the court has asked you to do something, if you know you can't get a stay, do it. If you don't do it, they will seize your asset. And that is what I want Nigeria to to focus on. This idea we are going to extradite Michael Quinn's son and what have you. Look,
I wonder how likely that will be.
That's not going to happen in a million years anyway.
All right. We have to leave you here now. Olufemi Aina, UK solicitor, thank you very much for your insight into this issue.
Thank you for
right.